Hi, everyone. In this lesson, we're going to be talking about agency, worker classification, and non-compete agreements. This is the first lesson of this course, Business 217, where we sort of set the stage for some important topics that we'll talk about maybe in more detail and in different contexts later on. So we're trying to lay the foundation and the framework for understanding employment in the United States and then specifically in North Carolina because rules can change from state to state. Okay, so from the very beginning, we understand that individual people have the freedom to form contracts and give themselves rights and privileges and bind themselves to certain things under those contracts. Now, there are a lot of restrictions in place to try to protect people from unfair situations, but in general, we have the freedom to form contracts with other people and other businesses, and that's completely fine. So somebody might ask, is regulation of employment even necessary? Why do we have all these rules? Wouldn't it be better if we just left everyone to their own devices and stopped interfering in the business process to allow the economy to be more efficient? And this is what we'll call the efficient market hypothesis, saying that the free market would encourage rational, non-biased behavior because you're always trying to select for the most qualified person, and thus that would make a business more successful, give them a competitive advantage, and businesses that are discriminating would be then forced out of the marketplace. Okay, so that's one view. The opposing point of view to that is, well, okay, but discrimination will still exist because employers are often faced with two equally qualified applicants, and you have to decide somehow there are imperfections in the marketplace that can allow a discriminatory business to still be very successful, even though they're being selective in a certain way that would be considered distasteful. So regardless how you think, we do operate in this country and in this state as business people. So we have to understand the regulatory environment in this country and in this state. So one thing we'll talk about at the beginning is the agency relationship. This is incredibly important. Both as an employee and as an employer, you need to understand what this relationship means. So an agent represents a principal. So the agent is acting in the place of a principal. If I get hired on to a job, I'm going to be expected to do certain things. And while I'm doing those things that are part of my job, I'm acting on behalf of my employer. Okay, so employees are agents of their employers. So employers are vicariously liable for actions of the employees. Now, this is incredibly important to pay attention to and to understand, because what it means is if an employee messes up and causes some damage, that means that whoever was injured can come back and hold the company, the employer, liable for those actions of that employee in many situations. So I have to understand that when I'm hiring people on, I have to be careful about who I select, how to train them, because mistakes they make can become my problem later on. Now, with that said, there are a couple of stipulations here. One is agents have a duty to act only as authorized by the employer. So one defense, if an employee goes out and does something that harms somebody, a defense available to me as an employer is that, well, this employee was acting way outside of what they were supposed to be doing. If I can show that they were acting in an unauthorized manner, like if they had taken a bunch of illegal drugs and went crazy and caused an accident or something like that, then I can significantly reduce or maybe even eliminate the amount of damages that I have to pay for as the employer. So if the employee is acting in an unauthorized manner, the employer might still be responsible to a third party, but the employee, the agent, would then be responsible to the employer, the principal. So maybe I can get a court to just throw out the case entirely. Or maybe it's the case that I'm still liable as the employer, but then I can try to go after the employee to try to get damages from them. Now, the likelihood of this happening is relatively low because most, especially low-level employees, aren't going to have a whole lot of assets, but it does give me something to try to defend myself. The principal also has a duty to exercise good faith in the relationship, using care to prevent an agent from coming to harm. That means I have a responsibility to provide a safe and healthy environment in which my employees will be working. Okay, so moving on from there, there are two ways in which we can classify workers that I hire. One of these ways is as an employee. The other is as an independent contractor. Sometimes we call these people freelancers. Sometimes we just call them self-employed. But here we'll say independent contractor a lot. So an employee is someone who works for the employer, generally speaking, is economically dependent on that employer. The hours and the methods of their work are controlled by the employer. The tools, materials, uniforms, whatever it takes to get their job done is generally provided by the employer. In contrast, an independent contractor generally is self-employed, not usually economically dependent on just one client, although there's a lot of variation on that. Generally has the freedom to choose how and when to do the work, generally has their own tools, materials, and uniforms. I'm usually hiring an independent contractor when I come in, want somebody to come in, do one thing for me, and then our relationship is kind of over until I need them again. Whereas an employee, I'm hiring to come in and work, 40 hours a week or however long it is that I want them to work. Okay. Now, one of the things about the American system is we just have these two classifications, and there's a whole lot of overlap and blurred lines and a whole lot of jobs that sort of sit somewhere like in an in-between space where it's not always easy to tell exactly what they are. So a lot of the controversy right now sits in like the gig economy. So think about Uber, Lyft, all these other companies that where people can just sign up and just choose when they want to go work and stuff like that. But there will be a lot of restrictions placed on them. So it's not always immediately clear. So we're still sorting out how that's going to be. So why is it important to understand the difference between employees and independent contractors? Well, the differences are pretty significant. So why would I hire somebody as an employee? This is when I want to have control over when somebody is coming to work, how exactly they're doing the job that I've hired them for. I want to have control over who exactly is doing the work. Maybe I want to have control over their appearance if I'm going to require them to either wear a uniform or maybe adhere to some grooming standards or something like that. And I can usually require them, this is my choice I can make, I can require them that this job would be their primary employment. In other words, if they want to go out and have a second job, they need to come to me for approval just to make sure it's not interfering with this primary job. Why would I hire an independent contractor? Okay, there's a lot of advantages here. Usually just breaks down to money, but I usually don't have to pay payroll taxes. The contractor would pay their own. I usually don't have to pay benefits like healthcare, retirement, sick leave, all this other stuff. I usually don't have to pay for overtime, tools, training, or travel expenses. I'm usually guaranteed satisfactory performance under the guidelines of the contract with the independent contractor. Vicarious liability on the employer if an employee messes up, but if an independent contractor messes up, my employer liability could be either nothing or much more limited. It would be on the independent contractor to make right whatever wrong has been done. Independent contractors generally are not protected by anti-discrimination laws. With that said, if the contractor is a business themselves and they have employees themselves, they'll probably be liable within themselves to adhere to anti-discrimination laws, but me as the business hiring the contractor wouldn't be. Okay. So there's pros and cons both ways. And where we run into trouble is where some employers try to get the quote best of both worlds by misclassifying employees as independent contractors. So this is, you're thinking about a business who wants to have a whole lot of control over who is working, when they show up, how exactly they do the job. But I don't want to do inconvenient things like pay for their tools. I don't want to pay employment taxes on them. I don't want to pay for benefits, all this other stuff. Okay. So what are the downsides of misclassifying someone? Well, I can end up owing employment taxes and additional penalties on this later on. I could get away with it for quite some time, and then somebody finally catches wind of what's going on. We can go back in time, figure out all these damages that I owe, and that's the kind of thing that can completely sink a business under once I all of a sudden have this huge bill that I have to pay. Often what would happen is a worker would catch on to what's going on. They would start asking questions saying, why am I under this control of this employer, yet I'm being paid as a contractor? Then they can tip off some government agency like Department of Labor or the IRS, which would then trigger an investigation into me. So generally speaking, the best practice here is to just classify people properly from the get-go to avoid having to worry about all that stuff later on. Now, I gave you some additional resources here. I'm not going to go through all of them right now, just in the interest of time. And this holds for all the lecture notes that I have up in the class. I try to provide links either to federal or state resources so you can learn more if you think, well, in my business, I really need to learn a whole lot more about this. So I try to provide those resources to you so you can learn more. So see those links there. There are a couple things like safe harbors where if it turns out that the IRS or the DOJ or DOL determines that I had misclassified, but determines that my misclassification was reasonable later on, I might be able to avoid some liability there. The IRS has another system to try to potentially avoid some retroactive tax assessment. So even if you find out you have misclassified, there might be some resources available to you to help avoid some liability as long as you are kind of acting in good faith and reasonably. Okay, so how exactly do we make the determination whether a worker is an employee or an independent contractor? It's not always completely clear. It's not always super easy. And there's not just one test. There are multiple tests. Which test a court or a government agency uses can depend on what kind of law we're talking about, where we're at, or maybe just the choice of a court. So we'll sort of talk about the prevalent tests that are out there. And you'll notice there's a lot of overlap in the different kind of tests. One of the big ones is the economic realities test, used for FLSA claims. That's the Fair Labor Standards Act. That's the law that gives you minimum wage, overtime, things like that. So this is a totality of the circumstances analysis to consider the economic reality of the activity, because it's not just always one factor that prevails. We have to look at all the factors involved to then try to make a determination. So some of the factors that are considered: what is the opportunity for profit or loss depending on managerial skill? So it would be kind of common for an employee to be paid a salary. So kind of no matter what I produce during that time, I get paid the same amount of money. But an independent contractor is going to have to manage their time and their money much better to be able to manage how big my profit or loss is going to be. Next factor, what investments are made by the worker and the employer. Okay, so like I said earlier, employer oftentimes is going to have to invest in training of an employee, providing all the tools, uniforms, whatever they might need. Whereas for an independent contractor, we're generally just talking about one price that's under the contract to do a specific job. And so the employer is not really making a whole lot of investment there. What is the permanence of the work relationship? We generally think that employees are hired on a permanent basis, although we know people can get fired and all that stuff. But generally, when you hire an employee, the expectation is you're here, forever, or until we decide differently later. Whereas for an independent contractor, much more common to just hire somebody for one job and then we don't need them anymore. Like if my plumbing breaks, I need to call in a plumber to fix it. I'm not necessarily hiring a full-time plumber to come on staff and be an employee forever. I just want somebody to come in, fix the problem, and I pay the money, and then we're done. What is the nature and degree of control over the work? This is a big one. So to what extent is the employer standing over the worker and making sure that they're doing work at a specific time, according to certain methods and certain protocols, as opposed to just hiring a contractor to come on, take care of the work. I don't necessarily care how it gets done. I just want it to get done, and then we move on. Next factor, whether the work performed is integral to the employer's business. So again, am I hiring people to do the actual business we're engaged in? So if I'm a microchip company, I'm making microchips. Okay, so any work that is involved in the process of making those microchips, that's integral to the employer's business. But if the plumbing breaks, I just need somebody to fix the plumbing in the employee bathroom, that's not necessarily integral to producing microchips. It's just something that I need to get done so that the employees have a bathroom to use. Finally, what is the skill and initiative of the worker? Am I hiring somebody on that's already skilled? They already have initiative because, again, they're motivated by their ability to get the job done and try to make a profit and then move on to the next job. As opposed to, am I hiring somebody on who's an employee who I'm going to train in order to do the job? So these are all different kind of factors under the economic realities test. And this is, in my opinion, the economic realities test is expanding, becoming more kind of the accepted test. There's also a common law agency test. Common law agency test, also known as the right to control test, seems to be used for Social Security claims right now, but it focuses on the amount of control parties have over their work. Again, that's really just overlap on one of those factors in the economic realities test. And then finally, there's an IRS analysis. This used to be called a 20-factor analysis, but the IRS has updated theirs, and it looks a whole lot more like the economic realities test now. It looks much more similar to that. It's an analytical tool to help employers decide how to classify workers. So if I go to the IRS website and try to figure out their tips for determining how to classify a worker, then you'll have I linked you to it, but you'll have a lot of reading to do that will help you make that classification. But like I said, recently revamped from their 20-factor test to focus on 3 categories: the behavioral, the financial, and the type of relationship. And if you read through it, again, you'll see a lot of overlap for the economic realities test there. So what about contingent or temporary workers, aka staffing firms? A worker could be considered employees. It kind of depends on the situation. This is a situation where I go, maybe I'm looking for a job, and I go to a staffing firm and I say, hey, here are the skills that I have. Can you find me a job? And they'll be working with companies who are looking for workers. And they say, well, we can match you up with this company on like a temporary basis. Okay, so I could be considered an employee of maybe the staffing firm, or maybe the business that I ultimately go to work for, or maybe both. So depending on who's controlling whom, who pays whom and how, who trains whom and how, the staffing firm and the client could both be considered employers, making them exposed to joint and several liability. Joint and several liability. Joint liability means that we're both liable. Several liability means that we're separately liable. So joint and several means it could go either way. Now, we'll talk a little bit about definitions, and it seems kind of silly to talk about who is an employer, who's considered to be an employer. It can make a big difference, because if I don't meet the definition of an employer, maybe I can avoid some liability later on. Contrary to that, if I know that I'm an employer, according to these definitions, I need to make sure I'm complying with the rules and regulations. So like I said, the definition can vary from one law to another. If we're talking about the Civil Rights Act of 1866, pretty much anybody. If we're talking about Title VII of the Civil Rights Act of 1964, we're talking about somebody who employs 15 or more employees for each working day in each of 20 or more weeks in a calendar year. Okay, so if you're on the edge, you just need to take a look and see, how many employees do I have for how many weeks in a calendar year to understand if I'm considered to be an employer. The Title VII here exempts some government-owned corporations, we would call them Native American tribes. The language in the legislation says Indian tribes, but now we would say Native American tribes, and bona fide private membership clubs. If we're talking Title VI of the Civil Rights Act of 1964, this extends Title VII protection to any program or activity that's receiving federal money, federal financial assistance. It also includes states and state agencies that are covered under the Civil Rights Restoration Act of 1987. You don't have to memorize every single one of these. Just be aware that I need to understand if somebody's suing me for something, or if I'm hiring people on, I need to understand all the different rules and regulations that I need to be following. So that's why we're looking at this list here. For a lot of very, 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 very small companies, you have to follow significantly fewer rules. For much larger companies, of course, you have to follow all of them. So for the Age Discrimination in Employment Act of 1967, anybody who has 20 more employees for 20 weeks in the current or preceding year, so that's the difference, 20 versus 15 for Title VII. For the Americans with Disabilities Act, we'll also call that ADA later, we're talking about 15 or more employees. Under the Fair Labor Standards Act, it can depend on whether we're talking about enterprise coverage or individual coverage. Enterprise coverage is given to employees of an organization as long as the organization has at least 2 employees, if they have annual revenue or business done of at least $500,000, or if you're a hospital, business providing medical or nursing care for residents, schools and preschools, and government agencies. Opposing to enterprise coverage, we look at individual coverage, and that's granted anybody regularly engaged in interstate commerce, which most people are engaged in some form of interstate commerce, and engaged in commerce or the production of goods for commerce. Okay, so you're probably going to be covered under the Fair Labor Standards Act. Most people are. It really just kind of, there's a couple things to consider there. Last definition of employer is under the Rehabilitation Act of 1973. This covers people who receive federal funds and government contractors. Also covers all programs and activities of any executive agency, as well as the United States Postal Service. Next topic, a covenant not to compete. We generally just call these non-competes. It could be an entire contract standing on its own. A non-compete agreement could be a clause built within another type of contract, like an employment contract. It's very important to understand, and there's been a very big recent development in this that some people might not be aware of. So what is a non-compete? Well, it's an agreement in a contract that restricts an employee's ability to work in the same field within a certain geographic area for a specific period of time. And whether or not that non-compete is going to be enforceable and valid depends on, well, how much time are we talking about? What geographic distance are we talking about? What are the other terms, and are they reasonable? Now, a huge decision that just came down from the Federal Trade Commission. They just issued a new rule that bans non-competes for most workers, and this passed in 2024, very recent. Now, we're not sure. This rule hasn't completely gone into effect quite yet. As of when I'm doing this June 10th, 2024. Hasn't completely gone into effect yet, but it does go into effect this year. So for most workers, most workers. So most people who are working as employees for companies, if you sign a non-compete, that will no longer be enforceable. And if a company tries to get you to sign a non-compete, then that new agreement would also be unenforceable. Now, I have to caveat this to say that this is far from completely settled, because the U.S. Chamber of Commerce and there are other conservative groups who have already announced lawsuits to try to block this new rule. They don't like the rule. They think businesses should have the ability to get employees to sign non-compete agreements. So it's going to take a little bit of time to see where this shakes out exactly. And if you're listening to this in the future, it might already be the case that the U.S. Chamber has convinced the Supreme Court to rule in their favor, or they might have challenged it and lost. Hi, everybody. This is Jeremy from the future, breaking in here with an update for the year 2025. This rule banning non-competes was indeed overturned by a federal court in Texas in August of 2024. The Biden administration, for whatever reason, maybe it was too late in their administration to try to challenge it, never really did try to challenge it. And now that the Trump administration has taken over again, they've made it quite clear that they're not going to be banning non-competes during their tenure, at least for right now. But this administration is kind of all over the place, so they could change their minds at any point and we could revisit the issue. I don't really see it happening. So we are going back to a world in which that FTC rule never happened. We're going right back to it being a state-by-state issue. In North Carolina, non-competes are valid as long as they follow certain rules, which I'm going to explain to you in just a second. But let's imagine a scenario where non-competes are enforceable again. So if they're allowed in a state, they need to be reasonable with regard to the amount of time, the amount of distance, the type of work that is performed. I can't just ban somebody from doing any kind of work anywhere for the rest of all time, because then we're taking away people's ability to make a living for themselves. How much is the non-compete going to restrict an employee's ability to go out and earn a living? Courts generally don't try to completely restrict a person's ability to make a living for themselves. And then finally, what is necessary to protect an employer's legitimate business interest? Is the employer's concern a legitimate one, or are they really just trying to kind of punish a person who might quit and then go try to work for a competitor? So in North Carolina, under the old rules, they had to be in writing, they had to be signed by the employee, and then some consideration had to be offered. So if we're talking about current employees that are already on staff, I would have to give them something, some amount of money. It doesn't have to be super huge, maybe an extra vacation day or two, whatever it would be, in order for that contract to be enforceable. However, if I'm hiring somebody on as a brand new employee, the offer of employment can serve as the consideration for that contract. North Carolina specifically, factors to consider when determining validity of a non-compete. What is the scope of the restriction? What is the area assigned to an employee? Where did the employee actually work? Where does the employer operate? What is the nature of the business? What is the nature of the employee's duty and knowledge of the employer's business operation? So again, you can go learn more about North Carolina specific rules, but if this FTC rule stands and goes into effect, then most non-competes for most employees will be unenforceable going forward. A few examples of some non-competes that North Carolina in the past had found to be reasonable and unreasonable. There was a 2-year, 25-mile radius restriction against a general surgeon from competing with his former hospital. 2 years, kind of a long time, but they found that the 25-mile radius was like, okay, you can drive 25 miles and go get a job somewhere else, and it's not going to kill you for 2 years. Another one was a 3-year, 15-mile radius restriction against a dentist from operating a practice in competition with his former dental office. Okay, so 3 years longer. That's kind of stretching the limits of how long a non-compete would be valid. That's really kind of at the edge. The court probably allowed it just because the 15-mile radius was limited in geographic area. There was also a 1-year, 2-state restriction against a former employee from working in a very specific industry because the employee knew sensitive information in those 2 states and his job was identical to the one with the former employer. So this was an attempt to try to prevent the spreading of trade secrets. Examples of some ones that have been found to be unreasonable. Some recent ones, there was a 3-year restriction on working for any other paper company within a 300-mile radius of any office or branch of a defendant company that had offices in 13 states. So that would eliminate a huge part of the country. It would make it very hard to get a job anywhere. A 3-year restriction on working for similar businesses within a geographical area consisting of over 20 counties in North Carolina or within a 60-mile radius of Greenville and Wilmington. Again, when you're making this geographical area so big that it makes it extremely difficult for an employee to go out and find another job, that makes it a higher likelihood that a court would not enforce that non-compete. Now, sometimes companies want you to sign non-competes, not because they think they're actually valid and enforceable. They just want to deter you from trying to go out and find another job somewhere because they want to hire somebody on. They're going to invest in that employee, and they want that employee to stick around and not then go work for a competitor working against me. I understand that sentiment. We just have to be careful as employers because a lot of us are going to go out there and be either managers or open our own business or whatever it might be. We just want to make sure that we're treating people fairly, allowing people to make a living while still protecting my business interests. It might be that I can use non-disclosures in place of non-competes just to make sure my trade secrets aren't getting out there. We can do non-solicitation agreements to make sure that employees aren't trying to steal all my clients and take them off to another competitor. So there are things that we can use to try to protect our business. But non-competes just might be a tool that we can't use very much anymore going forward, depending on whether the FTC rule stands. That's enough for this lesson. Hope you all have a great day.